for 2025. I am Dr. Alencia Bowen, the Dean of the Ross College of Business and the Executive Director for the Leadership Center and Co-Executive Director for the Global Center for Healthcare Education. And I'd like to officially welcome you to our session on Empowering Your Financial Future series. And we're going to be talking about estates and estate planning with Dr. Martina Peng. This is such a unique offering that personal questions will not be able to be answered. If you have specific questions regarding a topic or something that's shared, please feel free to put that in the chat and we'll be happy to address those questions at the end or as we're going through if it's something about a certain content. If you are in need of getting in touch with Dr. Peng after this session because you have something pertinent to yourself or your personal estate, please feel free to contact her on the email that will show up on her last slide. And then if you need information before, we'll be happy to put that in the chat as well. I am so excited that Dr. Peng is here, and I am just excited to have each and every one of you here for this session. Dr. Peng, I'm going to turn it into your hands. Before I do, I apologize that my camera decided to act up, and that is why I'm not able to show you my screen. But thank you, and we're in your hands.
All right. Well, thank you, Dr. Bowen. Give me one sec. I need to reset up my screen in order to share. All right. Should work now. Okay. Can you all see my screen?
Yes, ma'am, we can see it.
All right. Thank you, Dr. Bowen.
Yes.
Thank you. Thank you, everyone. All right, I am Martina Peng, and it's really a pleasure to be here to talk about estate planning basics with all of you. Well, first of all, let me give you some credits for spending the time, investing your time here. I guarantee you this is going to be a really good 1 hour of your time because the reason why you're here, I'm sure that you've wanted to do something to protect your loved ones. And I am very proud of you for having the thoughts and taking the action to join us today. So, what we are going to cover today is not to teach you how to set up your estate plan. Instead, we are going to go over the basics so that when you're ready to set up your estate plan, when you're working with a professional, you will understand the terminologies being used in the process. You will not be clueless. You'll know what they're talking about. And that basic knowledge is very helpful for you to move forward. And let me go through a quick overview of what we did in the Leadership Center Financial Wellness series. We started with looking at how you budget your money, managing your money, organize your accounts. We took a look at your investment, protecting your family. We looked at tax planning. Last series, we looked at retirement planning. And today, we're going to complete the circle by talking about estate planning. What is estate planning? It's really a process that will help you control who will get what you have. Okay, who do you want to give your house to? Who do you want to give this account to? And so far and so forth on. So and it's more than just that. It has included the financial decisions and the medical decisions that you are going to name someone to make on your behalf when you're not able to do so. So that is an overview of estate planning. And a lot of people would ask me, Martina, I don't think, do I really need an estate plan? I'm not one of these rich guys. All I have is a house and some retirement accounts, maybe some investment account, and that's it. I don't have much. I don't know if I really need one. Okay, so this is why we're going to talk about who will need an estate plan. So who exactly would need an estate plan? Now, I'd like it to be an interactive session. So if you have any thoughts and if you want to answer my question, feel free to put your answer in the chat box. I may not be able to check the chat box, but on the audience, you are welcome to communicate with each other. So let me ask you the first question. Do you think, based on what you have, do you need an estate plan? Do you need a will? Do you need a trust? Is that necessary? So my answer would be, first of all, if you own a house in the United States and you want to protect your house from going through the probate court, and you want to make sure that your family get your house without any issues, without any problem, without paying extra money, and you want to save your family time and money, you want to ease the burden on your loved ones by sparing them from having to make difficult decisions, then the answer would be yes. You will need an estate plan. And you really don't need to have much, just a house, just some assets, some accounts, then having a good estate plan will really benefit your heirs. Okay, so let's take a look at the important documents within an estate plan. And we are going to introduce the four key documents. The first one is a will. And this is not a term that you are unfamiliar with. I'm sure you're all familiar with what a will is. But let me first distinguish the differences between a living will versus a last will. So a living will, just by looking at the word a living will, it's really for someone who's still living. Okay, so a living will outlines your wishes regarding the medical treatment. If you became incapacitated, you can make that decision. So a living will help with that. But what we are going to talk about today, from now on, I will focus on a last will, and I'm just going to use the term will. Okay. So for a will, it really dictates how my assets, my property will be distributed should I pass. And there are several main purposes for a will. First of all is that the control of asset distribution. So I get to choose who will inherit what. I want my house to go to my kids. I want this account to go to my parents, and I want my car to go to my favorite charity. However I wanted, I can list it in the will. And another major purpose for a will is for those of you who have kids that you want to select the best guardian that you think most appropriate to take care of your children. And I know some of you may have grandchildren and you have adult children who may not understand the importance of having a will, which will help then pick the guardian for their kids. So for grandparents, this is as important as for those of you who have kids. Picking the right guardian is super important because without a will, who is going to make that decision for you? Okay, so I have kids. I don't want the court because if I pass without the will, it's very likely that everything will go to the probate court and the judge will make that decision for my children. Now, the judge will, of course, make their best decision based on their judgment, but they don't know me personally. They don't really know who would be the best person to take care of my kids. And I can give you an example. So there was a single mom who passed away, and she passed without a will. So the court decided to pick her brother to be the guardian for her children, for her son, and that's the son's uncle. So theoretically, that makes perfect sense, right? Because that's the closest family that the woman has. However, this lady, let me just call her Mary. Mary does not get along with the sister-in-law, which is her brother's wife. And the sister-in-law, it's a blended family. So the sister-in-law had her own sons, and she got married with Mary's brother. So this step brothers, and she doesn't get along with the sister-in-law her son does not get along with the sister-in-law's children either. So selecting the uncle as the guardian is really not the best arrangement for her son. Instead, if she were to have a will before she passed, she would have picked her best friend who lives in the same neighborhood as she does, and their children grew up together, and they are the best friend. Her friend knows her very well. That would be the best selection for her child. So that is why it's so important to have a will that you can make that very important decision for your child. When someone passes without a will, I'm gonna use myself example. So my son, okay, I don't want to break his routine should something happen to me. I want him still be able to do whatever he is doing. So should I pass today without a will, who is going to send him to school tomorrow? Who is going to take him to his swim practice? Who is going to take him to his band concert? Who is going to take him to all his activities? And all the kids are busy now today, so you don't want to break their routine while they grieve for the loss of their loving parents. You don't want them to be placed in a family service agency while the court is making that decision, which could take a long time. You want them to be settled, go back to their routine, and move on. So having a will, having the right guardian picked for them by the parents is super important, and that could have been done easily through a will. So that's the legal document for will and picking a guardian for your child. Pets. Now, our pets are just like our kids, and we want to find the best care for them. So in the will, you can dictate who is going to be the caretaker of your pets, and you know who your pets get along with the best, right? So you can have that choice made in advance. And also you want to minimize the taxes. So those are the advantages of having a will, and also the disadvantage if you don't have one. The second most important document within a will is a medical power of attorney. So a medical power of attorney is really when I am incapacitated, I can't make the decision. Who am I going to name? Who do I trust to make all the medical decisions for you? I definitely want to trust, I definitely want to choose someone that I trust and understand my wishes. So this person can make decisions about my medical treatment, including the procedures, interventions, and other measures, etc. Right? And if I don't have a medical power of attorney, what's going to happen is, let me give you a real example. And this is a case we use in our classes, but it's also a true story. So this woman, let me use the name on Mary again. So Mary got into a serious car accident, and she could not the doctor's prediction is that she's still alive, but they're not sure how long she will last for. And it could be years, it could be months. They don't know. They don't know when she will wake up. But if she does wake up, it's very likely that she's gonna lose a lot of the cognitive functions. She may not be able to walk again, may be paralyzed. So a lot of complicated situations with her health condition. And the doctor's suggestions for the family is to consider, maybe they want to consider pull the plug, because it's also very time consuming and expensive to use all the medical devices to keep her alive. So it's really the family's decision. Now, Mary did not have a medical power of attorney. So the the burden is on the family. The husband, knowing Mary very well, knows that she's very active. She really cares about the quality of life. So he knows she wouldn't be happy should she wake up and having to live like that without any quality of life. The in-laws Mary's parents did not want to pull the plug. They just cannot. They're still in the denial stage. They can't accept the fact that their daughter is in a serious condition, and they are praying for a miracle to come, which you can't blame them. They have two daughters. Okay, Mary has two daughters. The older daughter is with the dad. She agrees that she knows her. She's very close to her mom. She knows that her mom is very active. Her mom wouldn't be happy waking up like this. So she agrees with her dad that maybe it's time to just let her mom go in peacefully. Whereas the younger daughter is with the grandparents. She still cannot let go of her mom. She understands it's difficult, but she's still waiting for the miracle. So while everybody is heartbroken, everybody is exhausted from commuting from home to the hospital, taking care of the mom, they're divided. They are constantly arguing. They don't know what to do. So with a simple medical power of attorney, you can see how this can easily take care of the issue, the problem, the burden that's being put on the family. Now the family don't know what to do. They can't come to a consensus, and they are pretty much divided, and they are the husband doesn't want to take the responsibility either. He knows what his wife wanted, but he's also scared. He's also worried that what if he made the wrong decision? He's self-doubted. He doesn't want to feel guilty to be the so-called bad person, but it's really not. So we don't want to put our family in a situation like this. So having your medical power of attorney developed when you're alive, and it takes just a few minutes, 10 minutes, you can get it done. It's very simple. So this is a very important part for our estate plan. Now, in addition to the medical power of attorney, there's another one. It's the financial power of attorney. Now, very self-explanatory. A financial one is the power of attorney that I name someone that I trust to make the financial decisions for me when I am not able to. So, for example, when I am in a hospital, pay the bills for me, file my tax returns, um, things like that. So, having a financial power of an attorney is also super important. And here is why. So, here's another story. So John is he's an investment banker, and he obviously investment banker. He is an expert in finance, right? And he's a very responsible dad. He takes care of all of the financial affairs for the family. He pays the bills. He takes care. He files the tax returns. In fact, he files the returns for all their family members, their cousins, their in-laws, his own parents. So a lot of family members depend on him. He's a super nice guy, and he does this for years for everyone. So he has a lot on his plate, right? Then he got into a serious condition where he was fixing something on the gutter, and he fell and couldn't wake up, and he's still laying in the bed. He's alive, but the doctor did not know why that he is still unconscious. And it's been months he's laying on the bed. So the family is in a big trouble because nobody knows where things are. Nobody knows. He's been the person, the go-to person forever, that he pays everything. Nobody knows the passwords for all the accounts. And it could be as simple as the utility bills, the cell phone bills, things like that. And he does all of that. Now his family don't know where they how those accounts are paid for, how the bills are paid for. Is it by credit card, by their bank account? They don't know. They don't have access to the accounts. They don't know the passwords. And more than that, because of his condition, the family had a huge medical bill to pay for. They have assets, they have multiple houses, and it's all jointly owned by John and his wife. Now they do need cash to take care of the bills, so they wanted to sell one of the properties. And guess what? Because the properties are jointly owned, in order to sell the properties, they need John's signature in addition to his wife's. But John is not able to sign laying down there, so they can't sell the house. Now, the question now comes down to it's not that they don't have the money, it's not that they don't have the assets, but they just can't touch it without the financial power of attorney. There's no one that can make that decision for John or on his behalf. Therefore, you want to make sure that you have the right power of attorney within your estate plan. And that is why it's also part of the very important component within an estate plan. And the last one is a trust. And I put in the parenthesis revocable because we are going to talk about a revocable trust, a living trust. So what a trust is really just a legal document that provides some control over what your assets are, how you want your assets are handled. And on an easy way to look at it is it's just like you go out and you purchase a safe, okay? And you put it in your house. And what are you going to do with the safe? You're going to leave it, you're not going to leave it empty. You are going to put your valuable belongings in your safe. So it's the same thing as the trust. Now you have the trust set up and you want to put your stuff into your trust. And it's revocable, meaning that you can open the safe and you can take things out. If you buy something new, you can put it into your safe. You can always make an adjustment to your living trust. If it's a revocable one. And we won't talk about the irrevocable one today. The irrevocable one are the trust that for some people they want to make sure that they are fully protected by the creditors and they don't want to have any association with their assets, then they put it in an irrevocable trust, which you cannot make any changes to. But most people would just do a revocable trust. So the trust would be the number 4 important legal document in your trust, in your estate plan. And how does a trust work? So let's take a look at this graph here. First of all, you have your estate, you have a house, you have several accounts, and you are the creator of the trust. Legal term would be a grantor. You and your spouse would be the grantor of the trust. And when you are living, you will be your own trustee, meaning that you can make all the decisions, making changes to your trust. That's what a trustee does. So you will be your own trustee. You will pick a trustee to manage all your assets after you pass. So and this trustee's job is to make sure that your wishes are honored and everything is distributed the way you want it to your beneficiaries. Okay. When you are choosing your trustee, it's very important that you choose someone that you trust, of course. And second is someone who has the ability to manage your assets. So, for example, I love my mom. She's the person that I trusted the most. So, no brainer that I want her to be my trustee. But one, she's older than me, and it's more likely that she'll pass before I do. And two, she's in her 80s. So should something happens to me, I'm not sure if my mom is the one that can make the most informed decision and to be able to manage all of my assets and distribute them on the correct way. So even if this is the person that I trust the most, he may not be the best choice for my trustee person. So when you're selecting your trustee, you really need to think hard who would be the best person. And sometimes people have co-trustees. So for example, I trust my sister. I know she's very loving, and I know all the decisions that she makes will be in the best interest of my beneficiaries, and she gets along with my children as well. However, she's really bad with money. And I'm not sure if she has the ability to manage my assets. So I may add another friend or another sibling or someone else that I think has the knowledge, has the ability to help my sister, and together they can best manage my assets. So that's why sometimes people have a co-trustees, or you can have, say in my case, I may have my sister who I trust the most, or and then I can add a bank or a wealth management firm to assist my sister to manage the assets. Okay. And sometimes people will add a successor trustee. So should, if my sister is my trustee and if we both die in an accident together, then who is going to be my trustee? That is why she is my first trustee, but I also need to have a successor trustee listed in my trust. So that is how a trust works. And the main purpose for a trust is really to avoid a probate court. Okay, so you may ask, well, what is a probate court? I've heard the term. I'm not sure how it works. I'm not sure what does the probate court do? So, here are the things that probate court will do. First of all, if you have a will, they'll validate your will. They'll make sure that this is authentic. This is really in accordance with my personal wishes. This is not a fake will. Sometimes there are fake will. If I have a lot of money, I have a lot of estate, everybody wants a share of my estate. So people create a fake wills. So they will validate that in the probate process. And the judge will appoint an executor for or an administrator to manage the estate. And this person will, first of all, they will go to my house to take an inventory list, go through my stuff to see whatever I have left in my estate, create the list, and will executor will do all the administrative stuff to make sure that the assets are distributed. And the court will pay the debts if I have any. They will make sure that all of my debts are, that everything that I owed are paid off. And they will distribute my assets, of course. The probate court, the judge will decide the remaining assets after everything is paid off, will go to my beneficiaries. If I don't have a will, they will go through an order by law. Typically, the spouse will be the first one, and my children and my parents. And they will also handle the guardianship if I don't have a will. So the judge will decide who would be the best person to be my children's guardian. So that's what's happening in a probate court. A big problem with the probate court is that first of all, it's very expensive. Why is it very expensive? So if you can think about it, okay, let's go back. Okay, so to have the hearing, to have the court open, who's gonna pay for the judge salary? Who's going to pay for the person who takes the minutes, the recordings in my case? Who's going to do all the administrative work? Who is going to pay for the executor to create an inventory list of my estate and everything else? So everything will come out of my estate. And the AARP's research was that the average is about 10% of my estate, but typically it could be 15%, 20% of my entire estate. And I don't want that to go to the court and pay everybody else. Everybody wants a share of my estate. Sometimes when you have a challenging case, if someone wants to contest your will, you will need to hire an attorney. So attorney gets involved. If you have complicated financial situations, sometimes your family will need to hire a tax accountant or the court will hire a tax accountant and they're involved. So all of these professionals, they need to be paid and everybody is paid from your estate. And that is why if you go through the probate court, if you're lucky, 5%, 10%, or If you're not, your case is complicated, 20%, 25% will be gone, and your heirs would not be able to get 100% of your estate. So it's very costly. The second problem with the probate is that it takes a lot of time. It does take a lot of time. And here is why. So should I pass today? Okay, should I pass today? Do you think I can get on a schedule? I can be scheduled to the probate court for my case next week? Probably not, right? Because first of all, there are a lot of people probably died before me. So there's a long line before me, and I just need to get onto the wait list. So just to be get on, just to schedule my case will take, I don't know, 2 months, 3 months. That's very typical. And then finally, it's my case's turn, and the judge will discuss everything. And sometimes it's so complicated that it cannot be taken care of for just one court hearing. So there will be the second meeting, the third. So it can easily take 6 months to 2 years, sometimes longer than that. I have seen people who inherited their parents' house, supposedly to inherit their parents' house. After 4 years, they are still not the owner of the house because they got stuck in the probate court. They not only need to pay money in order to finish the probate process. And in this case, the man inherited a pretty nice house, but he has a 50,000 out of pocket fees to pay, let alone how long it takes him to actually inherit the house. So that is a long process that you do not want your family to go through while they're grieving for the loss of their loved ones. So costly, time consuming, and it's also public information. So everything that's happening in the probate court, it's public information. So in other words, should I die and my case went through the probate, if you are interested, you will be able to pull this record, public record, and find out, oh, let's see what Martina has in her estate. Oh, she has a house located XYZ address, and oh, she has bought a boat in what year, and exactly what she has in her estate. If you don't want your personal information to be public information, then you want to avoid the probate court. And speaking of the time consuming, I forgot to mention that the judge will also need to make it a public info to post my death so that all of the creditors will know that should I owe anyone any money, here is the announcement of my passing so that everyone has all this period of time in order to claim the debts. And that will be a 3 months, 6 months, and that will take a lot of time as well. So these are the disadvantages of a probate code. That's why you'd want to avoid it. Very costly, time consuming, and everything will be public information. So here's our question. How do I avoid going through probate? Well, there are several ways that you can do it. So let me show you three scenarios, okay? The first one is without a will. So say that I pass without a will, definitely will go to probate court, right? Because the judge needs to make all the decisions. So that's the first scenario. What if I am very diligent. I created a will while living and I got a will. What will happen? Will my case go through probate? You can put your answers in the chat box. I'm interested in your answers. Let's see. Maybe. Okay, I see some maybe. It still could if it challenged, maybe. Okay, yes, maybe. Okay, so this is the confusing part. If I don't have a will, definitely go to probate. If I have a will, okay, yes. it will still go through the probate process. So, friends, please remember, if you have a will, you will still need to go through the probate process before your assets can be distributed to your family, your beneficiaries. And here is why. Remember the last slide where we show what a probate court does? Part of the judge's job is to validate the will to make sure that it's authentic. So they're just honoring your wishes, but that's just the process. They still need to go through that whole process to make sure that this is really your personal wishes. So that validation process needs to happen in the probate court. That is why even if you have a will, you'll still need to go through probate. It'll just be faster because you have everything listed in the will, you have your guardian selected in the will. The judge just needs to check, 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 check. Okay, I'll check, making sure your wishes are honored. However, it'll still take some time. And just to get onto the schedule to have to go to the court, you don't want your family to go through that. So having a will is not enough. You will still go through probate. The only way to avoid probate is to have a trust. If you have a trust set up, everything will automatically go to your heirs, go to your beneficiaries. Now, I want to spend a little time talking about some functions that a trust can do. So this is very interesting. With a will, you typically would just give everything to your heirs. You decide that, oh, my house will go to my kids. I have two kids, they'll split it. My retirement account will be split by my two kids. It's very simple. But with a trust, there's way more you can do. And it's really an art. It's a lot that you can do in terms of how you want your assets to be distributed. So if you look at this slide, say that I have $1 million in my estate. And instead of giving a lump sum to my kids because I don't trust them, my kids are young, who knows what they're going to do with my money? What if they go out and buy a very fancy car or a house that they cannot afford? Maybe they can pay the down payment, but they are going to go bankrupt after 5 years. They can't pay the property tax. They don't understand how much maintenance it takes and the cost associated with having a really big house. They just don't have any idea. Or I don't have a responsible kid, or I have a sometimes we call a trouble child, trouble adult child. So in that case, I don't want them to have my $1 million immediately. What I can do, the way I can design how my money will be distributed is that I want 20% to be to be distributed to my children when they're in their 20s, and they get another 20% in their 30s. So I pretty much split everything. I spread it out so that they won't have a big chunk of money and not knowing what to do or can make a smart decision. So that's what I can do. Um, I've seen people I've seen a really beautiful case where this grandma um, loved her daughter so much. Her daughter is a workaholic. All she does is work 90 hours a week, doesn't take a vacation, doesn't do anything else, loves her work, just work, work, work. And her mom is very worried about her health. She doesn't have a family, she's not taking good care of herself, and she doesn't do anything fun. So the girl makes a lot of money, and all the mom wanted for her daughter is for her daughter to enjoy her life and to take a pause. So in her trust, the mom put aside a portion of her estate, and this money is a travel fund for her daughter. She wanted her daughter to use the money to travel to one country a year. And she has the money already set there for her so that her daughter can, this is the only way her daughter can access that money. Okay, let me just say that because the mom wants her daughter to enjoy her life. So there are so many ways that you can do a trust to design a way to help your children and to provide them a really happy life. Because we know our kids the best, or we know our loved ones the best. We know what they need, hopefully, and we can use the money wisely with the help of a trust properly designed in order to honor our wishes. I will share with you another story which I think is very beautiful. So this couple they they have 5 children, and the children live all over the world, different countries, different cities. It's very hard for their kids to get together, but this old couple, they want to leave a legacy. They want their kids to get together once a year, so they use part of their estate, the money in their trust, to set aside and invested to create a travel fund for their 5 kids, their families. Every year, they have this money setting aside for the 5 families to get together for their family trip. And this is a really good design how they distribute their money for their children. And that's something that a will cannot do, but a trust can accomplish. So when you think of a trust, yes, it's a legal document, but it can be designed in a way that your kids can benefit so much from your love and what you want from them for them. Okay, so I want to spend some time to talk about beneficiaries. When you set up your beneficiaries, there are 2 ways to set it up. This way, the first one we're going to talk about is per capita. So per capita means by the head, and on the to distribute your estate. All the estates will be distributed equally among the surviving beneficiaries. So in this case, um, Ben and Sarah are married, but it's a blended family. Okay. Ben has a son, Mohammed, and Sarah has a daughter, Hannah. So, but they are stepbrother and stepsisters. So, when Ben passed away, everything goes to Sarah, goes to the spouse. That's no problem with that. When Sarah passed away, it is Ben and Sarah's wishes that they want everything to be equally distributed among their 2 own children, Muhammad and Hannah. So they want each of them get 50% of whatever is left. Okay, so theoretically, that sounds perfect. What happened is that Mohammed passed in the same car accident with Sarah. So Mohammed is gone. And by per capita, his 50% share is gone because he's one of the surviving beneficiaries, and he's gone. So what happened now is everything will be left to Hannah. She got 100%. Do you see the problem here? So Hannah is not really related to Ben's grandchildren. So she is legally the aunt, but she's not biologically related to them, and she now inherited 100%, and the children got nothing. If she's very kind, she may share some of the estate with the kids, but she doesn't have to. So if you set up your beneficiaries in the wrong way, this could happen. What you really should do is set up by the per service. So per service means by the branch, not by the head, but by the branch. And that will ensure if a beneficiary dies, their share will pass down to their heirs. So it follow the family linkage. So per service will distribute the shares based on family branches instead of what we saw here. Okay, so let me give you an example. Same scenario, should the son pass away, his share will, instead of for Hannah to get 100%, his children each will get 1/6 of his sharing. Okay, so I hope that's clear. So when you set up your beneficiaries, it's very important to make sure that you set it up by per service. And when you open an account or when you have a new life policy and financial account, they will walk you through the questions. And what you need to do is understand the differences between the term per capita, which is by the head, and per service, which is by the branch, and you wanted to go by per service. Okay, so to do a quick recap, um, if you look at this beautiful cup and the dish, you can look at the cup as a trust. And you want to make sure that everything is in your trust when you have it set up. And the dish will be the will, which will catch any leftover that you forgot to put it in your trust. And you may ask, well, why would someone set up a trust and forgot to put things in there? Well, maybe you set up your trust 10 years ago and now you bought a new house or a new property or a new boat and you just forgot to put it in your trust. And that is very common. We see that a lot. So anything that's left out of the trust, it can still be listed in the will. So that's how you have a will and trust. It will give your family the full protection. Okay. Now, I want to go through 4 questions. These are the commonly asked questions that people have. So let me just walk you through that. So question 1, I have a will. Why would I want a living trust? Well, we just talked about the benefits of a trust. You don't need to go through the probate process, save your money, save your heirs' money, save their time, protect their assets, and you can distribute the way you want. So you can list everything in a trust. What if I do the joint ownership? Can I avoid probate? So, for example, I have a house and it's jointly owned by myself and my husband. Well, what if I add my son to the title so that if I pass, it will automatically be my son will have a share of this, right? Well, theoretically, yes. If I jointly own my house with my son, yes, the house doesn't need to go through probate because he will just get the house immediately. However, there are so many disadvantages if you do that. One of the biggest one is that if the house is jointly owned for me and my son, if he gets married, if he gets a divorce, his ex-spouse may have a share to my house, right? My if I decide to sell my house one day, I need my son's consent to sell the house, which I probably don't want to. And if my son gets sued and the house is the only thing that he has, it's under his name, it's very likely that they can take part of the house, which is again my house, jointly owned. So there are a lot of disadvantages that if you do a jointly owned ownership. There's another tax issue if you do that. So if I pass away and my son will inherit my house, he can skip the step up basis. Basically, the day of my passing is the market value of the house that he inherited. Should he want to sell the house, it will be the current market value minus the day he inherited the house. So if I purchase the house, say, if I purchased the house $200,000 years ago, and when I die, my house is worth $1 million. If my son decided to sell the house the second day, he basically has no tax due because we are going to use the day of my death as the purchasing value of the house, and he can take advantage of that. If it's jointly owned, okay, if he decide to sell the house, it will be 1 million minus my original price, which is $200,000. So there's a capital gain of $800,000 for tax purpose. So there is a huge tax disadvantage if I make it jointly owned. Another question that we people have about a trust is, what if I set up my trust and I put everything in my trust? Do I lose control of the assets? The answer is no. So while I'm living and everything in my trust, that's still me. I am the trustee. I have full control of my assets in my trust. I can take things out, I can put things in. I have 100% control. It's just like having your safe the example that we used earlier. So it's just like having my safe. I have full control of it. Some people would wonder, do I need to use a corporate trustee? So, what is a corporate trustee? A corporate trustee is just that you name, say, a bank or a wealth management company to be one of your trustees or to be your trustee to manage your asset should you pass. And the reason why you want to use a corporate trustee is sometimes I may not have a family member that can help me to be my trustee. I may not have any sibling. I'm the only child, and I don't really have a friend that I trust enough in order to do that job, in order to make sure that everything is distributed to my children. So instead, I could use someone professional. And the banks and wealth management companies, they all offer that service. You do need to pay a fee for them to do that, and it could be a percentage of your assets, but they are professional. They do that all the time. It's not super expensive, but they will make sure that your money is continue to be invested, and they will make sure that your assets are distributed properly or however you want them to be distributed. The number five, it's not a question, but I want to bring this up. The number one mistake that people make with their trust is that they have the trust set up, but it's empty. It's like I have my safe here and I didn't put anything in there. So you have the trust set up, but you did not fund the trust, meaning that you did not rename, retitle your properties, your accounts. You did not make the trust the owner of all of the assets, which is a big mistake because without funding the trust, it's empty. It doesn't do anything there. Okay, you have to fund the trust. And when you work with a professional to have your trust developed, um, typically they will remind you that, okay, these are your assets and you need to make sure that they are part of your trust. So that's what we mean by funding your trust. It's sort of like, have you ever seen people, they have set up their 401k, their 403b, or their health savings account, and they have the shell set up that make contributions to their accounts, but they forgot to invest, or they're not sure if their money is invested. So the whole point for having all these accounts is that one, you make the contribution, and two, you want your money to be invested so that you can take advantage of the growth, right? And delay the taxes. But if you did not have the money invested, you are losing the opportunity for the money to grow over all these years. So the same, similar to without funding your trust. All right, so next steps. So I'm really happy that you are here with us today and you learned all the basics about estate planning. And what I want you to do after this webinar is go back and review all of your accounts and make sure that your beneficiary list is updated. We have seen in so many cases that people have their beneficiaries set up correctly when they have the accounts opened. But As time goes on, things change. They may divorce, they may have new kids, they have additional children, they have grandchildren. So the family dynamics changes, and they never got to update their beneficiary list. And they don't realize that until, when they actually when the heirs start to inherited their estate and realize, oh, this is not correct. We have seen people's money all went to the ex-spouses and their current spouse gets nothing. So it's very important to pull all of your accounts, making sure your beneficiary list is updated. And remember, we talked about per capita, per Sturby, want to make sure that they are listed correctly. And number two, if you already have an estate plan established, that's great. Usually we want to review it every 5 years because your assets will change, your family dynamics change. So you want to make sure that your estate plan is current. Sometimes you want to name a different person for your power of attorney. If you do not have your estate plan established yet, you know what to do next, right? Next step is to get it done. And this is something that I know people want, they have good intention, they want to have it done. The reason why they don't have it done is typically people just put things off, right? Just it's important, but it's on your to-do list, but you never got to it. And this is something that yes, you do not have a hard deadline, but every day could be a deadline. It's not a project that's due next week. If you have a work project that's due next week, we'll come to it, we'll get it done by next week. This is as important, friends. So want to make sure that give yourself a deadline. Maybe by the end of January, get it done. And I guarantee you, you will have a really good peace of mind and you will be very happy because this is the best gift that you can give to your family. Last slide, knowledge is not power, even though we learned a lot. It's not power until you take some actions. So thank you everyone for your time. I wish you the best for the new year. And if you have any questions, here is my email address and you are welcome to contact me.
Thank you so very much, Dr. Peng. Those that asked the questions in the chat, could you please send that to her email, which is martina.peng, Peng, @franklin.edu, and she'll be happy to answer those questions that you asked. Thank you all very much and have a great afternoon.